let me now go to my presentation, which is based on a book that I published not too long ago. It's got 2 chapters by other people, and the rest of it is by me. And it came out of a seminar that I taught every other year at Santa Clara University Law School for many years. The origin of the seminar is that a very long time ago, I got interested in the legal system of Saga period Iceland because it was a real world example of something that some people in the law and econ community had been arguing about that was interesting. So I wrote an article on that. And I thought I learned some interesting things in the process of trying to make sense of that legal system from 1,000 years ago. Some years later, I got interested in the legal system of 18th century England, which was on paper our legal system, with the small detail that there were no police or public prosecutors. I only slightly exaggerate. So it was a system that it was our system, except that criminal prosecution was private, usually by the victim. And I wrote an article about that, and I learned some interesting things doing that. And then I was lazy for a fair number of years. And it occurred to me that I'd had a lot of fun researching those systems, and I'd learned things. And what I needed was a commitment strategy. What I needed was some way of getting me to do some more work. So I announced that I was teaching a seminar the next year on legal systems very different from ours, which meant I had to learn some more of them. And I went to the very nice people at my university library, the law school library, and they provided me a rolling bookcase, I think 3 shelves high, full of books, and I went through them. And then over the years, I added more things. I exploited my students. Human beings are social animals because we live by mutual exploitation, by benefiting each other by our existence. So my students wrote papers about legal systems, and I learned stuff from those papers. And eventually it turned into the book I'm going to be discussing. And obviously I'm going to give a very, very brief sketch of the contents of the book, but with a little bit of effort, you can find a late draft online. Scott Alexander actually linked to one, although it was a somewhat slightly out of date one when he was reviewing the book. And if you're feeling extravagant, I think my Kindles are generally something around $5, maybe $7, because one of the nice things about self-publishing is you can make your books cheap. So this is legal systems very different from ours. And it started out with a very simple idea. And the idea is that all human societies face about the same problems. They solve them in an interesting variety of different ways, and they're all grown-ups. You should take all of them seriously. There's no particular reason to assume that the people who created our legal system were more intelligent than the people who created the legal system of Periclean Athens or Imperial China or the Amish or the Romeny or any of the other systems. Each of them is one example of a way in which one can try to solve those problems. I was not trying to figure out what was the best legal system. I doubt there is one. I was trying to understand each of them and seeing what I could learn from them. The systems I cover range from Imperial China and Periclean Athens. I suppose I should have added Jewish law as well. Those are the 3 oldest ones. Through the modern Amish and Romeny. Those are societies that still exist and that run their own legal system more or less underneath the official legal system. This obviously is the quick version. For the full version, read the book. And the book is divided into what I think of as system chapters and thread chapters. The system chapters, which are most of what I'll be talking about today, each of them tries to make sense of one legal system. The thread chapters take some issue that runs through multiple legal systems. So for example, there's a thread chapter on the subject when God is the legislator. How do you handle a legal system where in theory you can't change it? And the obvious examples are Jewish law and Islamic law, but I argue that American law has a good deal in common with that, because we think of the Constitution sort of the way Jewish law thinks of the Torah. It's true you can amend it, but it's a real pain to amend it. So we end up working around it the same way the other systems work around their divinely inspired systems. But I have other thread chapters on other subjects. If you read the book, you'll see them. The systems I cover are Imperial Chinese law, Romany law, Amish law, Jewish law, pirate law, that's not by me, but by my friend Peter Leeson, prisoners law, based on a very interesting book by David Skarbek about the legal systems that prison gangs create inside prisons. Saga period Iceland was my first one. Somali law, basically the traditional stateless legal system of northern Somalia. Early Irish law. Three of the Indians, Amerindian groups, the Comanche, the Kiowa, and the Cheyenne. England in the 18th century, my other old article, and then Athenian law, which I find quite a lot of fun and which I like to describe as the work of a mad economist for reasons that may become clear. So let me start with Imperial Chinese law. One of the interesting legal issues is the distinction between tort law and criminal law. That in modern systems that we're used to, criminal law is enforced by the state. Tort law is enforced by the state in the terms of the enforcement of the ultimate verdict. But whereas with criminal law, you have government employees, the police and the prosecutor, who find out who did it and prove he did it. With tort law, all of that is up to the victim of the tort and his lawyer. And it's only at the stage when you actually get to a court and enforce a verdict where the government gets involved. And part of what interested me about Icelandic law a long time ago was it looked like a pure tort system, that there was no government institution for enforcing the law. There were courts and a legislature, but once you got your verdict, it was up to you to enforce it. It looked to me, looking at Imperial Chinese law, as though it was the mirror image, as it was the pure criminal system. And I was originally working from a book written, I suppose, about 30 or 40 years ago, which was based on high-level pictures from the Chinese literature, the way the imperial elite looked at their legal system. And it indeed portrayed it as a system with no equivalent of tort law, that if somebody wronged you, all you could do was to go to the district magistrate and accuse him of being a swindler. And it was then up to the district magistrate to decide whether to do anything. If there was a verdict, he was the one who controlled it. You were out of the picture. I then read some books written much more recently, because after the breakdown of the communist system, people got access to material from lower level courts. And it turned out that what was interesting, one of the things interesting about it was that it was a system which was criminal in form, but in fact, a large part of it was tort in substance, because the exception to the criminal part was minor matters. And minor matters were issues of marriage, debt, land, and inheritance. And the way those were handled, again, on paper, it was still a criminal system. But what actually happened was that you went to the district magistrate to complain. The district magistrate says, all right, I'll look at this case in a week or two. You then go back to the other party and you say, do you really want to get in serious trouble and get flogged or exiled or any of the bad things that can happen to you because this thing you've done to me happens to be in violation of one of the sub-statutes of one of the imperial statutes? We then bargain to an outcome. We then go back to the district magistrate. Unlike a tort case, we have no power to drop the charges. But the district magistrate is a busy man. So when we humbly request him to drop the case after we have settled it, he drops the case. So it's quite an interesting case of a system that on paper was all criminal, but de facto was much more nearly tort. Other interesting things about that system. The basic problem that they faced, and I'm thinking now of the late period of the 18th and 19th century, was that they were ruling a population of about 400 million people with a tiny civil service of elite scholar bureaucrats. And the question is, how do you do it? And one of the things that struck me about that system is that one of the things one hears about evil oppressive governments is that they force children to incriminate their parents. In Imperial China, to accuse your parent of a crime of which the parent was guilty was a criminal act by you. It was illegal to report your parents for breaking the law. Why? And I think the answer goes back to that problem, that the way you do it, part of the way you do it, is you subcontract the job of controlling people to other authority structures. The most important authority structure is the extended family in that society. You make it a crime to report your parents, because if you can do that, then the child has leverage over his parent, because he can. Everybody knows that people are occasionally doing things that are against the law, most of which fly under the radar, so to speak. And if children have the threat of reporting to the authorities, that breaks down the parents' authority over the children, and that breaks down the structure. And the rest of the system goes in the same way, that the system of punishments in imperial law is such that everybody in a family is categorized as junior or senior to each other. So your older brother is your senior relative. Your uncle is your senior relative, even if he's younger than you are. That goes by the tree, the family tree. Any offense committed by a junior relative against a senior relative, the punishment is ramped up. Any offense committed by a senior relative against a junior relative, the punishment is ramped down. So that whole system is set up, as I read it at least, to reinforce that structure. What else do? You make the legal system unpleasant to get involved with, so that people settle as many of their disputes as possible somewhere else. You do that in a bunch of ways. It is legal to beat witnesses, to torture witnesses to make them tell the truth. If you look at descriptions of the court system, if you want a good fictional description, there is a series of detective stories, the Judge D books, written by Van Gulik, who was a Dutch sinologist, who was basically taking the existing Chinese detective story literature, which was quite different from the Western detective story literature, and then trying to use that as the basis of detective stories that Westerners would enjoy reading. Judge D was a sort of Sherlock Holmes traditional character, but he gives portrayals of the system working. And it's a system where the judge is the high status person, everybody else is kneeling, is being very humble. In general, it really is not much fun to get entangled in that system. And as I interpret it, that was deliberate. Now, one problem with that is that it means that if I want to get an enemy, I can do it by accusing him of a crime, and he'll, even if he ends up getting acquitted, he'll go through hell before he gets acquitted. Now, the trouble with my doing that is that I'm entangled with the legal system as the accuser, so I go through hell too. The solution would be an anonymous accusation. The solution in the Chinese legal system is it is illegal for an official to read an anonymous accusation. And when that legal rule was originally made, there was an exception for essentially accusations of treason. And the next emperor removed the exception. So I think, again, I like to at least interpret these things. It's hard to be sure if I'm right, as intelligent people wrestling how to make their particular system work. Next puzzle about that system. There was a system of 3 levels of examinations, and it was that system that staffed the bureaucracy. There were, in the late period, about 500,000 people who had gotten through the first level. So that's about 1 person in 800, roughly, about 0.5% of the population. The next stage had a pass rate of about 1%. The third stage had a pass rate of about 3%. So this is getting to be a very, very elite system, one in which you will study for 10 years to take the exam. You will pass, you will fail the second level exam and study for a few more years and take it again, and study for a few more years and take it again. If you're very smart, you might get through the system by age 30, but you usually don't. What were these exams testing? Knowledge of the law? No. What they were testing was your ability to write poetry, to compose essays in a standardized form, to have studied in excruciating detail the Confucian classics, as well as other parts of the literature, and being able to write about it. So this is a real puzzle. What were they doing? Why do you have the ablest people in the society spend a large chunk of their life studying things that have nothing to do with the job that they're going to end up doing? Almost nothing. I exaggerate only slightly. And the question is, why do you do it? And there are a number of possible answers. One of them is that it's a very fancy IQ test, that you're selecting to get very, very smart people. A second, and I think perhaps more plausible one, is that there are really two characteristics you want in your bureaucrats. I should say a district magistrate is got a district of hundreds of thousands of people, and he is a combination mayor, district attorney, and chief of police. He is the representative of imperial authority. One of the characteristics is he be competent to do the job. And the other is that he wants to do the job, that he feels obliged to serve the people and be obedient to the authorities above him, to be the mother-father official. Well, if he has spent 10 or 20 years learning to be a real expert in the ideology of Confucianism, hopefully he has also absorbed that ideology and has been indoctrinated in it. And have you not only indoctrinated your officials, you've indoctrinated the couple of million other people who did the initial studying, most of whom got filtered out at the first level. So one way of interpreting it is in a way of indoctrinating in the ideology of the society a very sizable part of the upper part of that society. That's at least my conjecture. But it's an interesting system. And before we reject it as obviously absurd, we should consider that the imperial exam system is alive and well in the USA. That after all, one of the puzzles about the American educational system is why somebody who wants to be an engineer is expected to have taken courses in literature and writing and political science and God knows what else. Why we have a system where the entree to most of the high status jobs, even if not limited to the government bureaucracy, goes through at least a 4-year college experience, large parts of which are irrelevant to the job you're going to be doing. And what the explanation of that is, that's a puzzle various people, especially Brian Kaplan and some of his friends, have written about. I'm not going to talk about it here, but it is worth noting that it's something rather like the imperial system, which seems so crazy to us. All right. Next system, let's go. I should say the Imperial Chinese system functioned for something close to 2,000 years, with occasional intermissions in between dynasties. And a lot of it carried through. I've got some figures about how much of the last legal code exists 500 or 1,000 years earlier. Amish then are a modern society that most of us have heard of, though most of us don't know much about it. And I like to claim that the Amish are really anarchists. They're just very rule-oriented anarchists. And they are anarchists in two senses. The first is that the rules of each congregation are only binding on a member when, as an adult, he promises to obey them. The Ordnung, which is the set of rules, is specific to a single congregation of 25 to 40 households. The congregations don't get bigger than that because the Amish do not build churches or meeting houses. So the regular get-together of the entire congregation has to fit into a barn or a very large farmhouse designed to make that possible. When they get bigger than that, they split. The Ordnung is only binding on those who, as adults, have sworn to accept it. That when an Amish An Amish young man may have authority from his parents, that's as in almost any society, but he is formally, from their standpoint, not obliged to obey the rules of the congregation until, as an adult, he decides, in effect, to join the religion. The Amish originate as Anabaptists, as a Protestant faction which rejected infant baptism on the perfectly reasonable grounds that an infant cannot sign a contract and therefore cannot make a agreement he's bound by, and therefore they only you only become a member of it by as an adult by agreeing to be. If you choose not to, you're going to have much less close relations with the community. But unlike the punishment for somebody who's sworn to do it and broken the rules, someone who never joins it is still someone, just an ordinary non-Amish, who the Amish are free to interact with in any way they feel like it. How is the Ordnung changed? The Ordnung, in theory, is modified only by unanimous assent of the congregation. Now, one suspects there's probably social pressure involved, that the clergy, of whom there are 4 for each congregation, are probably decide what to do, and other people usually go along, but in principle, anyone can veto it, and if they veto it, in effect, the congregation is not at peace, hasn't settled its matters until something is worked out that everybody agrees to. The enforcement is by social pressure. The ultimate punishment is Maidung, which is ostracism. Ostracism does not mean nobody can talk to you, but it means that people are supposed to be very restricted in their interactions with you. So that one pattern you sometimes get is that if you have to make a money payment to a fellow member of your congregation who's been ostracized, you put the money down on a table and he comes in and picks it up. Husband and wife, if one of them is under Maidung, are not supposed to sleep together. The wife may request that she herself be ostracized in order that she can get back together with her husband. That's an accepted pattern. So what you have is a competitive system with multiple congregations. In the details of the Ordnung, of the rules, vary by congregation. Typically, there will be groups of congregations which are in fellowship with each other, meaning they have fairly similar ordinance, though not identical. In some areas, there will be a bunch of congregations in the same geographical area in the same fellowship, and then a member of one congregation who gets unhappy could just switch to a different one. In that sense, it's a sort of a competitive system. In other areas, it's separated enough so that if you want to switch congregations, you're going to have to sell your farm and buy somebody else's farm in a 20 miles away or whatever. But it is still a relatively competitive system with multiple congregations. How do you get the clergy? The clergy are selected by God. That is to say, members of the clergy are nominated by the congregation. The rules vary in detail from congregation to congregation, but basically I think 2 or 3 people have to nominate somebody. They then have a random selection in which one of these people is chosen to fill the relevant position. And being a clergyman, of which the top one is the bishop, and then there are 2 below that, and I think 1 below that, is an unpaid lifetime position. What is the system? What are these rules about? We tend to think of the Amish as being deliberately backwards, but that's an oversimplification. And it's arguable that they are the most modern, not the least modern, because what they are doing, as best I can tell, is deciding what technologies are or are not consistent with their social structure. And the details of how they do that vary. But for example, you have a congregation in which you are allowed to have a tractor, but it has to have metal wheels because that means you can't use it on the highway, only on the farm. You can't own a car. You can ride in a car. There are non-Amish Amish taxi cabs, which provide transportation services for the Amish. You can have a telephone in its own shack shared by several households, but you don't have a telephone in the house. All of this, I think, is designed to create a social structure which is inward facing, where you've got close relations with the other members of your congregation, but tend not to develop relationships far out of that. The Amish have been pretty successful in their interactions with the state. They got recognized as conscientious objectors way back. That then raised a problem, because what happens when you're a conscientious objector? They set you to empty bedpans in an urban hospital. You have a non-Amish roommate. You are interacting with non-Amish nurses. And by the time it's over, you may decide not to go back to the congregation. The Amish solved this problem by persuading the selective service system to let Amish conscientious objectors serve their national service on farms run by either Amish or Mennonites, who are sort of Amish light, interacting with other people like them. Problem solved. Social Security, there was a long fight with the Amish refusing to pay Social Security because they were supposed to rely on God, not on somebody else to take care of them. Their neighbors were supposed to take care of them, and did in old age. And so insurance of any sort is a gamble, and they don't believe in gambling. They eventually persuaded the Social Security Administration to make an exemption such that Amish who are employed by Amish or are self-employed neither pay nor receive Social Security. I think Amish employees of other non-Amish still have to pay. Schools, there was a long fight. Again, in the 19th century, things were fine, because in the 19th century, they were going to one-room schoolhouses occupied by local farmers very much like them. But in the course of the 20th century, you had a big shift of centralization, where people who were in rural areas were being bussed into the local city to attend large high schools with lots of other people. Furthermore, you had compulsory schooling going up to 12th grade. The Amish wanted to take their kids out after 7th grade to essentially apprentice at the job of running a farm or a household. The Amish refused to go along. There were extensive conflicts and civil disobedience. Eventually, the Amish won a unanimous Supreme Court verdict saying that they did not have to go to school after 7th grade. And the normal pattern is that after 7th grade, they are homeschooled, where the homeschooling basically consists of what they were doing before, namely learning to run a farm or a household. And at this point, a lot of the Amish are going to essentially 1 or 2 room schools for the first 7 grades, run by Amish, who of course are not qualified by the standard rules for running schools, but the Amish have gotten permission with state authorities to do that. And they seem to do a pretty good job, that essentially all Amish are fluently bilingual in their home language, which is one of 2 dialects of German, and in English. And the Amish, in addition to being quite successful at running farms, have also been pretty successful at starting small businesses. That would be a long story. I'm going into more detail than I should, because I find the Amish particularly interesting society. It's a successful system. There are about 250,000 Amish at this point, essentially all of them in the US. There may be a few still in Canada. They combine modern medicine with traditional birth rates. They lose about 10 to 20% each generation to leaving, to choosing not to rejoin. And the doubling time of their population is about 20 years. So if you live a long life, you will end up in a world where there are something over 1 million Amish. Romany. The Romany make an interesting pairing with the Amish, because like the Amish, they are a society which still exists. They go back much farther than the Amish, and manages to run its own affairs under the umbrella of a legal system. The ancestors of the Romany left India about 1,000 years ago. They scattered, so there are multiple Romany legal systems, which makes them especially interesting for me, because it's sort of as close as you can hope to get to controlled experiments in this sort of stuff, where you've got the same basic social system in different environments. One of the features that they share is a set of rules of pollution that I like to describe as Orthodox Judaism on steroids. The bottom half of the body is unclean, the top half is clean, and that has a lot of implications, including having to use different wash tubs for washing men's clothes, women's clothes, men's upper clothes, men's lower clothes, women's upper clothes, women's lower clothes, etc., multiple. I go into a good deal of detail in the chapter. It's an interesting system. How do they enforce these rules? There are basically two mechanisms. One of them, in some of the Amish populations, but not all, is a procedure called a Chris Romany, in which you assemble at least all of the adult males in the community, sometimes all of the adult males and females. This is when two people have a dispute and haven't been able to settle it. You keep arguing about it until consensus is reached, and that consensus is then imposed upon the disputants. And again, the ultimate threat is ostracism. The ultimate threat is marame. Marame is pollution. You can get marame either by violating the rules of pollution, and then there are ways of getting cleansed, but it's a nuisance. Marame is contagious. So marame automatically gives a form of ostracism because no other Romany wants to associate with you because they could get to be marame too. But you can also have marame imposed on you by a verdict of the Chris that you don't go along with. The other system, which is used, as far as I can tell, in most systems, in most such societies, is feud. I originally came across this with regard to the Romanichal, the main British Romany group. They don't have a Chris Romany. They have a much different and more decentralized system. But the ultimate enforcement is that if you cheat me, I threaten to beat you up if you don't compensate me. And both of us know that if you really did cheat me according to the social rules of our society, my friends will back me and your friends won't back you. So if you really cheated me, you either pay me off or leave town. And I like to describe that as a primitive version of the Icelandic system of 1,000 years earlier, which I had studied before. In the US, the Vlachram, who are the largest Romany group and who are the largest group in the US. There are a lot of Romany. I don't remember the figures, but it's in the hundreds of thousands, at least in the US. So comparable to the Amish, I think more. And the feuds in the US are largely done by using our legal system as their weapon. So if you have cheated me, to take a real example that I've got a detailed account of, I paid you for your daughter, because this is a marriage by purchase system, and I paid a bunch of money so that my son could marry your daughter. Your daughter then refused to have sex with my son, and I concluded that this was a scam, that you wanted to get her back and keep the money. So I go to the local authorities somewhere and accuse, I think her, though it could be you, of a crime, possibly one you've really committed, because the Romany are not very law-abiding, and I may know about one, possibly one you didn't commit. It doesn't really matter. The real objective is to get you in trouble with the legal system. And once you settled the matter and agreed to give me my money back, now I drop my charges and the problem goes away. There's a certain amount of violence as well, but as far as I can tell, the main weapon is using us as their tool, which fits the general Romany view of the rest of the world, as far as I can tell, which is that we are an environment, not people, and that the other Romany are people. In the Romany language, there is a word for a male Romany, there is a word for a female Romany, there is a word for a male Gaji, a non-Romany, and for a female Gaji, there apparently is no word for a man or a woman. Those are not categories that exist. Very interesting system. Again, I cite the things. It's an embedded system, that is to say, it's under our legal system. And for a long time, what they did was to stay below the radar. So, for example, the name a Romany gives to official people is community property of that family of Romany. Anyone in the family could be Joseph tomorrow. They, in various ways, don't register births, avoid being kept track of. This is working less well as the technology of the state gets stronger, but has worked pretty well in the past. They use that to avoid state law. The Nazis tried to eliminate both the Jews and the Romany. As best I can tell, they killed most of the Jews in the parts of Europe they controlled, and maybe a quarter of the Romany. We don't have very accurate numbers, but it was clearly a lot less than all of it. And I think the reason is the Romany strategy of not telling people they were Romany, not being in records to be easily tracked, and in general keeping a low. What is destroying the Romany system in the US, I think, is toleration. That the threat of ostracism works a whole lot better if there's nowhere else to go. And because in the US, we are a relatively tolerant society, it became easier and easier for Romany who got in trouble to function in the outside society. That reduced the strength of the whole system. There are two books by the same woman, Anne Sutherland, who spent some time back, I think, in the early 70s, interacting with the Romany community in California, and wrote a book about it. She then returned to those people published a book a year or two ago. And although she's not willing to say so, what she's really describing is the collapse of the system. It's somewhat sad if you find it interesting to have a world of diversity. And one of the things that struck me is that we're all in favor of both diversity and toleration, and they are to some degree inconsistent with each other, because the toleration reduces the mechanisms by which the diverse system maintain their own system. Athenian law, that's the next one. I like to describe Athenian law as the legal system of a mad economist because it's full of clever rules that might work and might not work. It was a system where all officials except generals were chosen by lot. We call it a democracy, and it's true that the laws were voted on by any citizen, any male adult citizens who made it to the assembly that day, but you did not elect officials at all. The legal system was privately prosecuted. There were officials, but by the time of Periclean Athens, which we're looking at, the officials handled the cases, as it were, but the prosecution was by a private citizen. And it was either the equivalent of our tort case, where only the victim or a representative of the victim could prosecute, or the equivalent of our criminal case, where anybody can prosecute. Why do you prosecute? There are two incentives, basically. One of them is that in many cases, if it ends up with a fine, you get part of the fine. And the other is that it's a way of hurting your political enemies. The obvious problem is you have a temptation to prosecute somebody who's innocent, rich, and unpopular in order to get money. They had a couple of solutions to that, which I will discuss a little bit towards the end of this, I hope. Another problem is, how do you produce public goods? How do you fund the Navy, for example? Because Athens had a Navy, it needed a Navy. And the answer was that if you were one of the richest Athenians, every 2 years, you had to produce a public good. That the relevant magistrate would come to you and he would say, you've heard we're planning to send a team to the Olympics this year. Congratulations, you're the sponsor. Or look at that lovely trireme at the deck. Guess who's paying for her this year? And this raises a problem. How do I prove whether or not I'm one of the richest Athenians? This is a society with no IRS, no accountants, none of what we're used to using measuring. And they had a solution to that problem. Can anybody who, well, I guess this isn't very easy to interact. I sometimes ask my audience if anybody can guess, but I'll just tell you the answer. The answer is that I am asked to do one of these things. I claim you are richer than I am. You deny it. You haven't been asked to do it, I should say. Or you have to do it every other year. So one defense is I'm already doing it this year, or I did it last year. Suppose I don't have that defense. I say, you're richer than I am. You say, I'm not. And I say, all right, I offer to exchange everything I own for everything you own. If you turn me down, you have just admitted that you are richer than I am. That's why I call it the system of the mad economist. And with a little thought, you can think of some problems with that system, but it's nonetheless a lovely solution to the problem of how you get people to self-reveal how rich they are. Other features of that system. Slaves can only testify under torture. This is true in Roman law as well, by the way. And I think the reason is that you mostly want a slave to give evidence against his owner. And the owner is in a position to punish the slave. And you therefore need a countervailing force. And the obvious problem is that arguably the slave will say whatever the interrogator wants him to say in order not to be tortured. The Athenians thought of that problem and they discuss it. There's a different legal system that had an interesting solution to that, which I'm not going to get into. But we have, in fact, two answers to this question. They are in the form of orations written for parties to law cases, because the party to a law case has to present himself. You don't have lawyers. But it was legal to hire an orator to write an oration that you memorized and then delivered. And some of these orations have survived and are one of our main sources for the legal system. And we have two orations, one of which points out the problem and says, obviously, you shouldn't believe the slave's testimony under torture. The other of which says, there is no example in the history of Athenian law, it has never turned out that a slave's testimony under torture was false. The two orations were both written by the same orator for different customers. Let me go on to 18th century English criminal law, which is the other one that I had studied before. That's a system which had our division between criminal and civil law, but there were no police or public prosecutors. I exaggerate slightly. If you actually committed a crime against the state, like counterfeiting, there were government lawyers to prosecute you. But for ordinary crimes, there were not. Any Englishman can prosecute any case. I think English women can too, but I'm not certain of that. Why do you bother to prosecute? The obvious argument is that our tort system works that way. All right, it's the victim who sues, but the victim then collects damages if he wins the case. Criminal case, if you win the case, they hang the guy, or maybe they transport him, or maybe there are some other outs from hanging, but none of them involve his paying you. And there are two answers, I think, which I discuss in detail in the chapter. One of them is that I charge you with a crime in order to get paid off to drop the charges, in order to settle out of court. This is illegal, it turns out. In fact, it's the original meaning of compounding a felony, is accepting a payment to drop felony charges. However, I think the evidence suggests that it happens pretty extensively. I've got some evidence for that. And therefore, it's doing, in effect, what the Imperial Chinese system did in a different way, converting criminal into tort by arranging to have a payment, even if a illegal and de facto payment for doing this. The other reason is that you make deterrence a private good. And you can see that if I was somebody who was likely to be the target of many thieves, if I'm running a business, I'm dyeing cloth and there's valuable cloth sitting there drying in the sun and somebody can come by at night and steal it, I want the reputation that if you steal from me, you end up getting hanged. That is not going to apply to very many people. The elegant solution they came up with was to create what was called an association for the prosecution of felons. And this is a group of people in one town who pay an annual dues to the association, and the pooled money is used to prosecute anybody who commits a felony against any member of the association. It looks like insurance, but I don't think it is, because the final step is that the list of the members of the association is published in the local newspaper for the felons to read. It's a pre-commitment strategy, just like the way I got this book written, that having paid in advance, if you didn't pay in advance, once you're the victim of a theft, you're likely to say, doing anything about this is going to cost more than it's worth. I'll just swallow my loss. But this way, you've paid in advance. The thieves know you've paid in advance, so they'll go steal from somebody else. So that was a sort of an elegant solution to the problem of how to convert deterrence from a public good to a private good. The legal system is also interesting in that all serious crimes were capital. That for anything, I can only think of one exception, for anything we would think of as a serious crime, the only possible sentence was to be hanged. However, the evidence from samples of courts that some people have looked at was that if you were charged with a capital offense, a so-called non-clergible felony, your chance of hanging was about 1 in 8. Even if you were convicted, it was less than even. And there were multiple ways out. One of them was that you could be transported to 17 years of indentured servitude in the New World. You had to agree to be transported, and the court would offer to pardon you if you agreed to be transported. Ditto if there was a war on, if you agreed to enlist in the Army or Navy, which always needed men. But they also just pardoned people and sent them home. And I discuss in some detail different theories of why you would go to all the trouble to convict somebody and sentence him to be hanged by the neck until dead, and then send him home again. And one answer is that it's price discrimination, that they don't want to bother hanging somebody if they're pretty sure they've scared him enough so he'll never do it again. One of them is that it's really a market for mercy, and I discussed ways in which non-monetary payments are being made to the authority structure, in which part of the way you get a pardon is when lots of important people ask the judge to pardon you. And why do that? Because you've done nice things for whichever important people were closest to you, the local squire, who then asks the local lord, who then asks his representatives in parliament, who then ask the judge. It's a complicated system, and I actually have a real world example in some memoirs of that happening. And the final theory is behavioral economics, that they were a little bit ahead of us back in the 18th century, and they figured that the deterrence was not being done in a rational system of people who estimated the expected probability of getting hanged, that if you hanged a small number of people and made a big show of it, that would scare them more effectively than routinely hanging lots of people. Whether that's right, I don't know. But I've got three different explanations. Let me go on to Islamic law, which people talk about a good deal and mostly don't know much about. Islamic law, in theory, Islamic law has separation of law and state, that the law comes from religious sources. It's not made by the ruler. The Quran and the Hadith. The Hadith are the traditions of what Muhammad and his companions did and said. It has developed elaborate rules of interpretation, including the difficult scholarly problem of figuring out whether a tradition of what the prophet said was really true or not, which involves tracing the transmitters and the authority of the transmitters, the reputation of the transmitters, whether you've got different chains of transmitters for the same authority, and so forth. It's ended up with 4 mutually orthodox schools of Sunni law. None of them consider the others to be heretics, but they all recognize that because you're using an uncertain process to figure out what God wants, therefore on the details you can disagree. I like to say it's like common law as it would be in a world run by law professors, because it's the scholarly work of the religious scholars that's the basis for legal interpretation, which is the equivalent of law review articles today. It combines law and morality, that the rules are both what you ought to do, so that, for example, if you are trying to decide whether it's religiously right to do something, this may involve no dispute with anybody else, you go to an expert, to what's called a mufti, and you ask him for an advisory legal opinion. That's what a fatwa was. And if it's just a case for yourself, that's it. You go home, you follow his advice. If it's a legal dispute, once you've got your fatwa, you now go to the qadi, to the judge who's been appointed by the ruler, and you show him your fatwa. And that's evidence not of whether anybody's guilty or innocent. That's for the judge to decide, but of what the legal status is of the controversy. So it's like our system turned upside down, that in our system, the court of first impression first decides whether you're guilty and what you should be sentenced to. The appeals court then decides whether the first court's interpretation of the law was correct. In their system, the mufti first decides what the law is, and then the judge, who hopefully respects the opinion of that mufti, decides what the verdict is. The system got destroyed. It no longer exists. The closest equivalent at this point would be Saudi Arabia. The last year I taught this course, I had a classroom filled with Saudi Arabian students going for their LLM degree. So I had primary sources in the classroom, which was a lot of fun. And there are parts of the Islamic law that still exist in Saudi Arabia, but it's really a compromise between that and modern law. Some of the scholars claim that what destroyed it was colonialism, but I think they're wrong. I think it was the rise of the nation state, because you see the system breaking down in the Ottoman Empire, which was never a colony and is breaking down in the Ottoman Empire well before the point at which the Ottoman Empire is a failed state and is eventually collapsing. So I think it was really that this was a decentralized system which depended on the local judges having a lot of authority based on the religion, and was replaced by essentially state law. So when people today say that they want to introduce Sharia into their system, they aren't really doing it. What they're really proposing is to take some of the features of the traditional law and make them into state law. It's a polylegal system in that within a medieval large city, you would have law courts for the 4 schools of Sunni law, plus probably the Christians, the Jews, and the Shia, and that's interesting. To some extent, you had a choice of law, that when you're signing a contract, you might be able to decide which court you registered the contract in, and then it would be that court's legal rules that applied, just like forming a corporation in Delaware today. As long as all disputes are intra-communal, among people who are all following the same legal system, there's no problem. There's a problem for cross-claim cases. And I'm pretty sure that cases between a Muslim and a Christian or a Jew can be taken to the Muslim court. Beyond that, it's not clear. And I think there are different rules for deciding which court decides such a case at different times and places. Let me say a little bit, but I'm running out of time, on feud law, which describes the Icelandic and the Somali system, and to a considerable degree, the Romany system. My first book, written almost 50 years ago, I sketched an imaginary structure for a stateless modern society in which law enforcement was private and decentralized. One of the things I got out of the research that produced this book was the conclusion that I had been reinventing the wheel. That what I wanted, that what I was describing was a high division of labor, modern version of something that had existed in much more primitive forms in a variety of past societies. The basic logic of feud law is that if you wrong me, I will harm you unless I am compensated. Such a system has 4 problems it has to solve. The first problem is, how do you prevent it from being used for extortion? You need some way in which, if you really have wronged me, my threat is much more believable than if you haven't. So you need some mechanism such that right makes might. Second, you have the commitment problem. I threaten to harm you, and you say, well, you harm me, I'll harm you. I can fight back. So you need some reason why I will carry out my threat once I've made it. And you need a reason which survives past death, because otherwise I make my threat and you respond by killing me. So we need some way in which my threat against you actually survives me. And that problem has been solved. You need some protection for the rights of the weak. You need some way in which people who don't have access to ways of using violence to enforce their rights can nonetheless get their rights enforced. And you need a way to terminate feud, that people imagine a feud going on forever. And there may be systems, broken systems where that happens, but the feud systems I've looked at, it doesn't happen. They normally terminate pretty fast. What you want to avoid is the situation where you do something that I think wronged me. I threaten to harm you. You think you're in the right, so you refuse to pay me off. I retaliate. You now think you've got a case against me. I refuse to pay you off. It goes back and forth and back and forth. This is the imaginary American Appalachian case that you've all heard of, which it turns out is mostly fictional. I discussed that in the chapter. But you need some way of keeping that from happening. Real legal systems have shown solutions to all 4 of those problems. How do you solve the right makes might problem? You need some reason. And the way in which you do that is, in Saga period Iceland, there was a legislature, there was a law code, there were courts, there was no executive arm of government. So if I win my case and you refuse to pay off, you get outlawed. It is legal to kill an outlaw and illegal to defend an outlaw. So if you try to fight me, everybody who gets injured on my side now has another case against you and your defenders and is going to win that case. So my coalition will keep expanding, and in practice, people don't do that. That there are a few people who, there are, I think, 2 cases in the sagas of people who last as outlaws for something like 15 years, but it's not by, it's basically by going into hiding, as outlaws are expected to do. Normally, you either pay off or you flee the country. The same thing as the Romany in England today, in that system. More generally, you need some form of reputational enforcement, some mechanism such that all the third parties who have most of the force around have low enough information costs so they know who is the bad guy, and therefore are likely to support the good guy on that quarrel and not the bad guy. Extortionists are not desirable neighbors. Next problem is commitment mechanisms. One of them is built into every one of us, and that's the emotion of vengefulness. As you may know, this system and private property predate our species. There are multiple other species that have territorial behavior, and the way territorial behavior works is that the animal, usually a bird or fish, but there are territorial mammals, including us, marks the territory he claims, and somehow turns a switch in his brain such that if a trespasser of his own species comes on, he will fight more and more desperately the farther onto the territory the trespasser comes. Unless the trespasser is much stronger, a fight to the death is a loss for both players, because he's likely, even the winner is likely to get injured. Hence, once you recognize the commitment strategy, you usually back off. I would claim that human beings have a much fancier version of that same mechanism. But one part of it, every one of us has experienced, that if I stand up and bump my head, my first reaction is rage. It's entirely irrational rage. Nobody else is responsible. But nonetheless, that's the way I'm hardwired. And the same thing happens when you feel somebody has wronged you, you want to get them, and you're willing to pay not an infinite cost, but a substantial cost to do that. Reputation. If I back down from my threat, I am marking myself as somebody who can be wronged with impunity. So somebody else may cut wood in my forest, may seduce my daughter, may kill my son, may wrong me in some other fashion. So I want the reputation of somebody who you don't want to wrong. Status. Being a wimp is low status. Human beings care about status. How do we solve the problem past death? My kin inherit my claim. They want the money, and they want to establish that killing members of their kin group is expensive. So that's how that set of problems have been solved in real world system. Protecting the weak. My favorite protecting the weak solution is Icelandic, and that is that tort claims are marketable. So I'm a poor elderly man, my only son is killed. If I try to sue, I know that I will be beaten up on my way to the court. And if the guilty party got outlawed, I'm not going to be able to kill him. The solution is that I have a neighbor who has 4 strong sons who went a Viking in their youth. He has kinsmen, he has friends, he has allies. I transfer my claim for 200 ounces of silver, which is a lot of money to him. He sues and collects. Maybe I get some of it, maybe I don't, depending partly on how hard it was for him to collect. But the killer pays, which means that violating the rights of the weak is costly. And after all, in our criminal system, the victim doesn't get the fine either. Somalia does a similar thing, but they have pre-existing coalitions structured in part by kinship, but in part by explicit contract, where the members of the coalition have contractually specified rights to share in the damage payment if one of their members is injured or killed, obligation to help pay the damage payment if one of their people loses a court case and has to pay. So it's a somewhat more organized version of the same system. Terminating feud is the next problem. How do you terminate feud? You can see the problem. One solution in Iceland is you have either the court or Somalia, an ad hoc court. Both of them have court systems. Once I lose the case in the court, I can now back down without looking like a wimp. If you wrong me, you can't expect to win the case next time. So that's one solution. Another solution is an arbitrator. We find somebody who is powerful and respected. We promise to accept his ruling on our dispute. If he rules against me, I accept. I again don't look like a wimp. Same reason as before. And if I don't accept, the other side now has a powerful addition to its force. What does this tell us? It does not tell us whether a stateless system is better. These are a very different set of institutions, very different societies. But it does tell us that it is possible for private institutions to replace government in its most central function, which is law enforcement. And as I said at the beginning of this, in my first book, I sketched a hypothetical system of that sort for a modern world, and I now know that I was reinventing the wheel, that such a thing is at least possible. Whether or not it is possible under current circumstances, we don't yet know. All right, let me go on to sketch very briefly the thread chapters that I mentioned. One of them is when God is the legislator. I like to say that by the standards of the rabbis, every Supreme Court justice in history was a strict constructionist. That if you compare rabbinic law to the actual content of the Torah, which is supposed to be the source of rabbinic law, you discover that the rabbis find all sorts of ways of interpreting around the law when they think it's a mistake. And you get similar issues in Islamic law, perhaps a little less clear. And of course, we all, at least Americans, are all familiar with the fact that the Supreme Court in the 1930s found that a farmer who was growing crops to be fed to his family and his animals on his own farm was substantially engaged in doing so in interstate commerce, and therefore could be regulated under the Interstate Commerce Clause of the Constitution, even though under the Constitution, Congress can only do things the Constitution says it has the power to do. And that's the decision under which large parts of the regulatory state were justified, under which it is made illegal under federal law to grow marijuana in your backyard in California, where doing so is legal under state law, and consume it yourself. So that's an extreme case, but the rabbis consistently outdo the Supreme Court in that respect. And it's not clear that it's a bad thing. I'd happen to disagree with that Supreme Court decision, but if you're stuck with a set of legal rules that are, as it were, written in stone, on some stone tablets, there's nothing you can do about it, it makes a good deal of sense to find excuses for changing them. Embedded legal systems, of which the two examples that I discussed in some detail are the Romeny and the Amish. They face a set of problems. How are they going to enforce their rules when in executing people will violate the laws against murder of the society they're under? And basically the two ways you do it are either to have enforcement mechanisms which are not illegal, such as ostracism by both the Romany and the Amish, or to do your or to stay far enough under the radar so that you can violate state law, as Romany pretty routinely seem to have done, without getting caught most of the time because you're invisible. Incentive to prosecute, I'll say a little bit more about. I've got another slide on that, but that's the basic problem is if there's no incentive to prosecute an offense, it doesn't get prosecuted. If there's too much incentive, then innocent people end up getting prosecuted. Guarding the guardians, that's the problem of you've got somebody who's got the job of enforcing the law. How do you enforce the law on him? That's qui custodes ipsos custodiet. That's the Latin for who will guard the guardians. It turns out that that originates in a Latin poem which has nothing to do with politics. It's about the problem of how a husband keeps his wife faithful. And the problem is that he sets some friend to watch the wife, and then the wife bribes the friend by sleeping with him. That's a brief summary of the argument in the poem, and I thought it was rather funny that that's where this phrase originates. There is, in fact, an English poem I'm quite fond of by Matthew Prior called The English Padlock, which is a better solution to this problem, which ends up that let her all her ways be unconfined and set your padlock on her mind, which I rather like, but that's a digression, but it's a nice poem. But in any case, But the problem of who is to guard the guardians is a problem we all have. How do we prevent police from murdering people? How do we prevent all sorts of authorities from doing bad things? And I discussed the various mechanisms for doing it. The problem of error. How do you deal with the fact that courts make mistakes? How do you get an incentive for courts not to make mistakes? And the mistakes, and the obvious solution for an economist is that when it turns out that somebody has been convicted of a crime he didn't commit, that then you punish the prosecutor. And the obvious problem with that is that if you have that rule, it gets even harder to discover that somebody is innocent when he was convicted, because most of the relevant evidence is in the hands of the enforcement authorities who don't want to go to jail themselves. It's enough of a problem already that if you read the stuff on DNA exonerations, it's clear that the authorities are often very reluctant to allow people who think someone was innocent to get at the evidence to prove it. And that's presumably because they don't want to be shamed by having it demonstrated that they made a mistake. Sometimes you can get through that, but that's obviously a problem. And then making law, and I discussed various arrangements ranging from the Islamic and Jewish system, in which you have legal scholars who take a body of text and figure out for themselves what the implications are for the law, through legislatures and competitive systems like the Amish, where in effect the law is being made on a competitive market by consent of the people involved. So I discussed that. But let me go on to the particular case of the incentive to prosecute. No incentive, nobody gets prosecuted. How do you get enough incentive? One solution is a state employee, a bureaucracy. That was the Chinese system. That was our criminal system, whose job is to prosecute. One solution is a damage payment. That's the Icelandic solution. That's the Gypsy blood feud. That's our tort law. One solution is a bounty for private prosecutors. That was the Athenian public case. One solution is extortion. That is to say, out-of-court settlement. That was what I argue is part of what was really happening in 18th century England. And of course, that's also part of what's happening in our tort system, because not all tort cases are resolved by the court giving a verdict. A lot of tort cases settle out of court, where you're using the threat to get a verdict in order to get somebody to pay you the damages you think you claim. And finally, private deterrence, where the incentive to prosecute is to have the reputation that people who wrong you will get prosecuted. And I describe how the English solved the problem of making that workable for small players as well as large players. But you then have the problem of too much incentive. In Athens, the problem was that given their court system, you could have somebody who found somebody was unpopular and rich, accused him of some offense he hadn't committed, get him convicted, and then shares in the large fine. And the Athenians had two solutions for that problem. For the public, the Athenian jury was a big jury. It was about 300 people. We don't know the exact details, and it depended partly on the kind of case. If the prosecutor failed to get at least 20% of the jurors to vote for conviction, the prosecutor got fined 1,000 drachma, which represented several years' wages for an ordinary worker, though presumably less than that for the kind of person who would be playing these games. In their equivalent of a tort case, for at least some tort cases, we don't know enough to know if this applied in general, the losing tort plaintiff owes the defendant a sixth of the amount he claimed the defendant owed him. And in mid-18th century England, there was concern with insufficient prosecution. They set up a system of rewards, and that system of rewards then resulted in people either being entrapped or being framed for the reward. And there were some very large scandals. It turned out that a fair number of people had been hanged who hadn't done anything. Eventually, they hanged some of the people who were responsible, and they backed off on that system. And in modern America, we worry that class actions and punitive damages may result in suing people who aren't guilty in order to say, look, we've got a 5% chance of winning this case, but if we win it, you'll give us $100 million, or how about you give us $5 million and we'll drop the case. So that's an issue. The nice thing about private deterrence is that private deterrence, you have an incentive to try to go after people who are guilty. Because if you have the reputation that when somebody steals your dyed cloth, you grab the first homeless person to wander past your door and somehow railroad him to get hanged, the real thief will know you're a safe target and keep stealing. So you can argue that private deterrence is the only system, at least I know of, which has a built-in incentive to get the right person. Ideas we could use. This is really the final chapter. One of them is marketable torts, that at the moment, if somebody dents my car and I don't know anything about lawyers, I don't know how to find a good lawyer. If I could just sell my claim to the highest bidder, then whatever law firm could do the best job of collecting damages would pay me for it. I then just become a witness. The Athenian rule for damages, either a punishment for prosecutors for overcharging criminal law or damages owed by tort claimants who lose. I discuss the case of what are called patent trolls, of people who arguably collect lots of patents and then sue on a weak case because people will settle rather than litigate for various reasons, and that would become less attractive if losing the litigation meant that you owed damages to the person you had sued. And I offer some law and econ arguments for why it would be appropriate for people who lose a tort case to owe some damages to the defendant. And in England, private deterrence, and you can think of ways of making it easier to use private deterrence as an incentive in our system. All right, that's the end of the slideshow. I now click to exit. I now close that window. I close my other window in which I was keeping track of everything. And we are now finished, I think. You can read the book
David,
for all the stuff I didn't say.
David, can you take some questions now? I'll read out.
Of course. I'm delighted to take the question. This went a little longer than I expected, but it's a fun subject.
Great. And so now I'll read out some questions. After that, as a reminder, we're going to split off into video chat rooms. And we shared the URL and we'll share that again. So a question from Jason Crawford, the general one, combining with a more specific one from Spencer Chen. How do the features of the system correlate with scale? Which features don't scale? Spencer Chen was asking specifically, what's the population size that a typical district magistrate governed?
Yeah, that's an interesting question. Imperial China is a big population, and I don't have exact numbers, but my impression is it was likely to be 100,000, 200,000 people, something of that on that scale. Iceland, on the other side, the population of the whole island might have been as much as 70,000 people. It was scattered around the island, around the coast almost entirely, because the central part of Iceland is mostly glaciers. There were no towns, no real population centers at all. There was one, I suppose you could say there was one town for about 2 weeks each year, namely the Althing, which was a national assembly where people from all over Iceland came, and I suppose several percent of the population. So there would have been maybe 1,000 people, 2,000 people there for 2 weeks. And that was both where they had the highest level sets of courts, but also where you set up marriages and trade and, general social interaction and such. So that was one. The Somali system, I think the population was substantially of Somaliland, northern Somalia, which is what I'm describing in the chapter. I think the population was surely in the hundreds of thousands, maybe in the millions when it was a functioning system, but I'm not really sure. And as far as I can tell, those systems can scale. What you need in the Icelandic system is a single court system that everybody recognizes and therefore will take as evidence of who's the bad guy. And in the Somali system, a recognized set of mechanisms for setting up an ad hoc court. So I think those systems, although we're observing them in relatively early societies, and the question of why you only observe them in such societies is an interesting one, I think they do probably scale to larger populations. And as I say, the Imperial Chinese one we know scales. Now, Jewish law is a particularly interesting case because the Kingdom of Israel is effectively eliminated sometime in the first few centuries after its last serious revolt against the Roman Empire. despite which most Jews thereafter were living under Jewish law. And the reason is that Christian and Muslim rulers over the diaspora usually found that the easiest way of dealing with their Jewish subjects was to subcontract ruling them to the Jewish communal authorities in exchange for taxes. So that you had a system in which until about the late 18th century, most Jews were under Jewish law. There were quite a lot of them, certainly in the millions. I don't think we have good population figures. They were scattered around the world in different communities. There was no Supreme Court. There was no mechanism for determining what Jewish law was. At any given time, there might be some scholar, one or two scholars who were regarded as the best authorities, but it really was a system which depended on, as it were, local groups voluntarily following what they thought were the authoritative rulings. I go into more detail in the chapter on that as well. So I think all of these systems seem to scale with population with different mechanisms. Another question?
Yes, Tom Fetterman is asking, how different are Amish congregations in practice? How much choice does one have? And Grocking Stuff asks, in a similar vein, can members choose to follow another ordinum while still interacting with the community? For example, a wife and a husband in different ordinums.
Yeah, I'd be very surprised if a wife and a husband were in different ordinum, and given just the structure of that society. They vary a lot. The lowest, which from their standpoint means the strictest, because the Amish are basically strongly in favor of humility, and therefore low is a positive term rather than a negative term. But the lowest congregations have very strict rules. I think there are I've really been talking about what are referred to as the Old Order Amish. There is a continuum within the Old Order Amish. I would say that any group that allows its members to privately own automobiles is not part of the Old Order Amish. But subject to that, you have a wide range of things, such as, are you permitted to have a telephone outside of the house? Are you permitted to have a tractor with steel tires, with steel wheels? Are you permitted to use a modern powered baler on top of a horse-drawn wagon? If you aren't allowed to have so the detailed rules, as far as they know, vary quite a lot. As far as I can tell, shifting congregations does not get you into trouble. The only thing that gets you into trouble is violating the rules of your congregation and refusing to back down and apologize for it. So that, as best I can tell, now I'm not sure about the very lowest ones, because they're stricter in various ways. For example, in the lowest ones, I believe the bishop can change the ordinum without the unanimous assent of the population, whereas in most of them it requires that. But my impression is that if you didn't violate the rules and just decide you want to change, you're still, a fellow Amish, just in a different congregation, and you're interacting just fine with the members of your old congregation, except that, they're not as close to you anymore. If you violate the rules, they're very strong on forgiveness. So basically, if you violate the rules and then publicly apologize, you're all right, as long as you don't keep violating them. If you keep violating them and end up, instead of making yourself good with your congregation, joining another congregation, they may or may not regard that as enough so that you can associate with them again. And this, again, there isn't a uniform set of rules. So I discussed some of this stuff, and more of it is discussed in the sources that I cite in my chapter on the Amish.
Marcin Kovrigo, excuse me if I mispronounced it, asks, based on the study of these various legal systems, what is the most dangerous failure scenario that may affect Western societies in the next decade? Are there any
most dangerous what scenarios?
Failure scenarios.
Failure?
Yes. Are there any important timeless, cross-culturally tested rules that we neglect in our society based on these studies?
I don't think anything occurs to me. I'm looking mostly at what worked, not what didn't work. The Icelandic system eventually broke down, although it lasted for about a third of a millennium. It was set up really about 930 AD, and the final, they turn over the country to the King of Norway in the 1260s. So it's about 330 years after about a 50-year period of increased violence as the system was breaking down. And I think that is relevant to the question of what would be the risks to the kind of stateless system that I've described, but since that isn't what now exists, it doesn't describe a failure mode of what we now have. So the answer is, I don't at least have any obvious insights. I could think about the question of answers to that question.
Jason Crawford asks, is there a sort of free rider issue with the Amish? Could they actually exist in the modern world if they were not embedded in a larger, different system?
I think the answer is they couldn't exist if the society they were embedded in was not a relatively tolerant one. I like to say that the biggest difference between the Amish and the Romany is that the Amish have much better PR. That the Amish are viewed by the rest of us as a sort of quaint but admirable version of 19th century rural America, which we tend to sort of admire even if we don't want to do it ourselves. And that, as I've suggested, is not a very accurate picture, but the result is that combining that plus the fact that they really are willing to engage in civil disobedience when they feel strongly about an issue at more or less any cost, that they take their views very seriously, they've been very successful in interactions with the US government, sort of surprisingly successful, I would say. I think there may still be some Amish in Canada. I don't think there are any anywhere else. That the last Amish in Europe joined with one of the less extreme related Anabaptist sects maybe 50 or 70 years ago, something like that. So I think that they depend on the society they're embedded in being a tolerant one, but it's not clear to me that they couldn't function with no over society at all. We don't have any examples of that because there aren't any places for them to do that, so I don't really know. But they don't make much use of the over society. That is, if you rob an Amish, they aren't going to call the police. They're very reluctant to testify in court because, in general, they don't really believe in the use of force and violence. They're pacifists of fairly extreme sort, which is one of the things people nowadays have a hold against them. That they argue that things we regard as criminal happen, and the Amish, if they discover it, want you to apologize and stop doing it, but they don't want to punish you. So I think they depend, given a state, in its being a tolerant state, and that it's interesting that the U.S. is apparently now there may be other places they could and just haven't tried. But the U.S. seems to be the only place we know of tolerant enough so that the Amish thrive in it.
Okay. Scott Owens asks about the connection between the rise of Islamic radicalism and the collapse of Islamic law, or with the institution of Islamic law. For example, the Muslim Brotherhood, Al-Qaeda, Islamic State, Afghanistan. Yes. To what extent are they establishing Islamic law, or to what extent is this connected to what you described as the collapse of Islamic law?
Islamic State, when I said that the closest to the real system that now exists was Saudi Arabia, I had a mental reservation for the Islamic State because it doesn't really exist in the sense of being a stable, established governmental structure. It may or may not be surviving and so forth. They at least talk as though they're trying to do the real thing. And it's very hard to tell, since what we're getting is either their propaganda or the propaganda of their enemies. It's hard to tell how real it is. And I don't know to what extent sort of remnants still survive in places like Afghanistan, where you never had a very strong state. But I've wondered, there's the older puzzle, in a sense, before you worry about radicalism, is why it is that in the 9th century, Islam was in some serious sense well ahead of the West. And by the 19th century, it was well behind. And there are a variety of possible explanations. There's a philosophical explanation, which was that there was a conflict in about the 9th century between what are the two schools of philosophy, one of which we describe as rationalist, and the rationalists lost eventually. And it may be that resulted in a less progressive in a non-political sense of the term culture. But what we do know is that the Islamic world was in some sense quite an attractive and productive place early on, and that became increasingly less true as the West developed. But no, I think that Islamic radicalism, I'm inclined to see it more nearly as a result of the fact that it became clear to everybody that in a world sense, the Islamic states were second-class citizens, that they were poor, they weren't developed, that their elite wanted to adopt stuff from the Western world and to Westernize, and the population, naturally enough, felt as though that was the meaning. And I think that encouraged people to find something they could glory in. Or what can you glory in? We have the true religion. It's, in a sense, is an interesting parallelism with China, because China, before Mao died, was one of the poorest countries in the world. The people in China, certainly the elite, believed they had the best economic system in the world. And when Mao dies and the elite can go abroad and discover how much worse off they are than the rest of the world, they suddenly say, wait a minute, we must be doing something wrong. How can it be? And you end up with China essentially abolishing socialism while keeping the name socialism as a result of that. And you could imagine that happening. I suppose to some extent it was happening in some of the Islamic states, in places like Iran before the Shah was deposed. But at the same time, that's a humiliating experience, and people would rather believe, no, we're the heroes, we're the good guys. And Islamic radicalism is a way of doing that. But I'm afraid I really have paid very little attention to modern Islam, because it isn't very interesting. That what the title of the book is Legal Systems Very Different from Ours. And my only real exception was 18th century England, because I had already studied it and it was really interesting and was relevant to a bunch of the things I was looking at. But other than that, I haven't been looking at modern legal systems, because I think if you looked at the modern legal system in most of the Muslim countries, it's really modern law with some overlay from Islamic tradition, rather than a real Islamic system based on, as I say, the central doctrine is separation of state and law. Now, of course, even in the Middle Ages, that wasn't fully followed, just as separation of church and state isn't fully followed in American law either. It really can't be if you think about it for a while. But so that you had chunks of state-made law existing at the same time. And that becomes clearest in the Ottoman Empire, where there is the Kanun, which is sultanic law. And in theory, the Kanun is just sort of supporting and implementing the Islamic law, but in fact, they're sometimes inconsistent with each other. But the doctrine was always that law was made by God, not by man. Another question?
Yeah, let's do one more question, then we'll go chat with each other. Tovia Moldwin asks a meta question. What kind of research went into the book? Is it mostly reading from other writers, or did you do any field work?
I did no field work. Well, the only thing that counts as field work is the last year when I had a bunch of Saudi students in my classroom, at least one of whom was the daughter of a woman who was a law professor in Saudi Arabia. So, but in general, they knew a good deal. I had one student whose paper involved trying to get information about the traditional system more or less at first hand. So that's about as close as it comes. But I was almost entirely working from secondary sources. And as I described in the case of the Chinese law, my initial secondary source, I eventually concluded, was quite misleading, because it was giving me the picture of Imperial Chinese law that the imperial elite held, but not an accurate description of that law. That the de facto system, when you got to look at what the local courts were doing, was noticeably different from the imagined system. But no, I'm working almost entirely from secondary sources. I was thinking about the question of how I can show you how I can get all of you to see my meetup. And so what I'm doing is I've got another page, browser page, which I've just opened, which I'm taking to my meetup. And if I can figure out how to do it, do I have to stop presenting in order to show another?
Stop presenting, and then you can present that page.
Very good. That's what I was about to do. Stop presenting, present now, and a window, and select the window, and I allow that. So are you now seeing my little, wait a moment, you should be seeing my little space. And I've just,
Yes.
boom, and that's the place. You can move around in it. You can, it's on Mozilla Hubs and on my webpage somewhere if you can find it. I've had references to it in various places. I have the link, but you can just do a search for Mozilla Hubs and they will tell you all about the interface, which is not perfect, but is pretty neat in my opinion. And as I say, at the moment, I'm the only person there. As you can see, that's why there's one person there. But it's got a variety of things that people have built in order to make it more ornamented. I think somebody even turned one of my rooms into presumably a bathroom. This one is a lounge, but that one, I did not do that. I built the basic structure and then people added bits and pieces. So it's sort of fun, and currently we've been meeting at 1 p.m. Pacific Coast time every Saturday, and we'll continue to do that, and you can pick up the URL from that. I haven't figured out how the chat works. If I figure out how the chat works,
we will share that.
All right, you can, why don't you do that then, because I don't know how to do that. And I've decided I'm also going to have a meeting at 10 a.m. The Pacific time on Saturday, so that people who are in places like Israel, where my 1 p.m. is something too close to midnight, can join in, and we'll see if that works. So for this next Saturday at least, you can try either 10 a.m. San Francisco, San Jose time, or 1 p.m. And we'll see if that works. All right, I will now close down that window.
Okay. So thank you very much.
I will stop presenting.
Thank you very much, David. Everybody feel free to unmute, because now is our chance to applaud. Thank you very much. That was great. And now we have a chance to keep on conversing with each other. So as you see in the chat, there are 3 different chat rooms.